Hello, greetings again, ladies and gentlemen. This is Doug Michael. We're going to continue with our Exposing History series with this video presentation, which is entitled Destroying the Illusion of History Part 3, the 13th Amendment Controversy. Endall and I had quite a few conversations over whether to present this topic or not because it is one of major controversial contention, and like the Common Sense Revolution Part 2 video, we're liable to piss people off in the sovereign citizen movement again by addressing this particular topic, but it merits a common sense discussion, so here it is. One of the major elements that is driving the sovereign citizen movement is the idea of a hidden or expunged 13th Amendment to the Constitution that cites penalties for loss of United States citizenship for anyone receiving a title of nobility from any foreign government. Within the Patriot movement, the presumption is that these titles of nobility apply specifically to lawyers, judges, and bankers who append their names with the title of Esquire. In the case of more rabid extremist perspectives, this is often applied erroneously to police officers as well. In all honesty, there was a proposed 13th Amendment to the Constitution prior to the present 13th Amendment banning slavery. The present controversy, which has gone on for many years, has to do with the argument about whether this original 13th Amendment was ever ratified by enough states to enact it into law or not. On the side of the Patriot community, you find those that claim a vast conspiracy to cover up and intentionally hide this amendment because it means that everyone using the title of Esquire should lose their United States citizenship, according to the provisions of this proposed amendment. The Patriot community claims that the Bar Association in America is simply an extension of the British Bar Association and that all lawyers in the U.S. are therefore secret agents for the British Crown, and that the title bestowed on them as Esquire puts them in violation of the Constitution as well as this hidden 13th Amendment. Now, I realize that the information to follow is liable to poke holes in the sovereign citizen movement ideas about this 13th Amendment, also known as the Titles of Nobility Amendment, or TONA, but when investigating history, one must go with what's on the record, not simply what sounds good or what one wishes to be true. Unfortunately, in the case of the Patriot movement, the evidence places their beliefs into the wishes it were true category. The original 13th Amendment was proposed to Congress on January 18, 1810. The amendment was voted into acceptance by the U.S. Senate on April 27, 1810, and subsequently accepted by the House of Representatives on May 1st that same year. The amendment reads, "If any citizen of the United States shall accept, claim, receive, or retain any title of nobility or honor, or shall without the consent of Congress accept any present, pension, office of emolument of any kind whatever from any emperor, king, prince, or foreign power, such person shall cease to be a citizen of the United States and shall be incapable of holding any office of trust or profit under them, or either of them." Since there are no records of debates within the Congress over this amendment, its purpose to this day is a matter of conjecture, with many believing that it was residual sentiments against foreign powers such as England and France, who still utilized such titles in their governmental structures. Once the Congress voted for the amendment, it was sent to the states for approval and ratification. Ultimately, only 12 states officially ratified the amendment, which fell short of the 3/4 majority of the states to adopt the amendment. This is a major bone of contention between the Patriot movement supporters who are still trying to get the adoption of the amendment acknowledged in order to support their belief system, and others who don't feel their arguments are on sound footing. You also have to remember the national sentiment at the time the amendment was proposed, after only completing the Revolutionary War a couple decades before and just 2 years prior to the War of 1812, that serve as a serious consideration about this amendment's drafting. The anti-foreign sentiment in the country was running pretty high, and the public concern over officials with foreign titles holding office in the federal government, yet who owed fealty for their titles to foreign kings, was a major concern for a newly independent nation. The fact is that in those early days of the Republic, communities were spread far, and transportation and communication was not what it is today. There was confusion over whether the 13th Amendment had been ratified by the requisite number of states, and this confusion was noted the first time it was ever printed in what is known as the Byron edition of the Laws of the United States. The publication of this edition was authorized by Congress in 1814. Because of the doubt at the time as to whether the amendment had actually passed the ratification threshold, the publishers placed a disclaimer in the book stating, "There has been some difficulty in ascertaining whether the amendment proposed, which is stated as the 13th, has or has not been adopted by a sufficient number of the state legislatures to authorize its insertion as part of the Constitution." The Secretary of State very readily lent every suitable aid to produce full information on the question, but the evidence to be found in the office of that department is still defective. It has been considered best, however, to publish the proposed amendment in its proper place, as if it had been adopted, with this explanation to prevent misconception. Supreme Court Justice Joseph Story, in his Commentaries on the Constitution at section 1346, written in 1833, stated in reference to the 13th Amendment that it has not received the ratification of the constitutional number of states to make it obligatory, probably from a growing sense that it is wholly unnecessary. Although the 1839 edition of Bouvier's Law Dictionary made no comment on the proposed 13th Amendment, the 1848 edition stated that the amendment has been recommended by Congress, but it has not been ratified by a sufficient number of states to make a part of the Constitution. With all of this public information available, it is very hard to give credence to the idea that the original 13th Amendment ever passed the ratification threshold to be enacted into law, and its continual printing with law books and statutes containing the Constitution with this amendment added appears to be more of a case of compounding printing errors for 50 years than some secret conspiracy to bury it. At some point, the decision was made to stop printing the amendment and replace it with the anti-slavery 13th Amendment, which was ratified by the necessary number of states, and the original misprint was simply replaced. As much as some sovereign citizens may wish to deny this, as it seems to be a core belief of their ideology, this is where the evidence points. David Dodge, a member of the Patriot movement, was one of the driving forces behind pushing the acceptance of this amendment, basing his claims that the amendment had been ratified on the fact that it had been printed in so many law books where the misprint continued. Despite the printing of the Constitution with the 13th Amendment added, subsequent printed versions did not have the original disclaimer provided in the Byron edition of the Laws of the United States, thereby lending more confusion to the matter. Subsequent investigation provides absolutely no supportive evidence from the collective state legislatures of the time to indicate that the amendment ever met the required threshold to become law. I'm posting a link to a law review article published in the Southern California Interdisciplinary Law Journal, published in Volume 8, 577 in 1999, entitled The Missing 13th Amendment, Constitutional Nonsense and Titles of Nobility, and that's authored by Joel A. Silversmith, if my viewers want more comprehensive explanations on the matter. The next area of this sovereign citizen doctrine we want to address is all this stuff about the title Esquire being indicative of fealty to the King of England, or Queen as it may be. The working theory in the Patriot community is that the American Bar Association, the ABA, is simply an extension or franchise of the British Bar Association. Whether this assertion can be remotely true or not, our own investigation can find no sources to support this notion, and no incorporation or franchise papers of any kind that can sustain this belief. The sovereign citizens movement relies on the belief that the United States turned itself into a corporation during the Reconstruction era after the Civil War, which lasted for 12 years, while the southern states were under the military occupation of the Union armies. Although the Reconstruction was a very dark period of American history that some refer to as the Second Civil War, the period does provide fodder to the Patriot movement to support their theories. We will readily admit that the Northern Republicans controlled the Congress in what is historically known as the Rump Congress, controlled by radical Republicans who are also known as Jacobins. This is all a matter of historical and public record and can be easily investigated if one chooses to do the research. During the Reconstruction era, the Congress passed a bill to incorporate the District of Columbia to ensure that the inhabitants of the district had the same constitutional protections as the states. This happened in 1871, and it is this act to incorporate the District of Columbia that the Patriot movement claims that the United States incorporated itself, and that is the source of all of this effort to expunge and hide the original 13th Amendment. Much of the research provided by the Patriot movement is filled with propaganda and a selective reporting of the facts in order to entice the sovereign citizen wannabe into their camp. In many cases, they are fast and loose with definitions that sound convincing in order to sell their patriotic product, but much of what they push as the law is meaningless. For instance, within certain circles of the sovereign citizen movement, we find the word bar, as in the lawyer's bar certificate, defined as British accredited registry, which they claim as proof of their claim that lawyers who hold bar certificates are agents of the Crown. There is no such thing as the British Accredited Registry. It is simply a term made up to sell an ideology to those who are too uneducated in the law to know the difference and who won't do the research that we did to refute it. These Patriot followers also suggest a definition of the word bar to mean British Admiralty Registry, so it seems they just can't seem to make up their minds on which definition they want to use to play their acronym games with. Another failure in this sovereign citizen folderol is the arguments over jurisdiction. Many of these people claim that the police and the courts have no jurisdiction over them as sovereign citizens. They claim that they are natural citizens of, say, the Republic of Pennsylvania or New Mexico. Now here's some news for you folks that spout this. As per our research, there is only one state in the Union that was ever an independent republic before statehood, and that is Texas, which established itself as a republic after its war with Mexico and before it joined the Union as a state. None of the other states were ever republics, so claiming that you are a sovereign citizen of the Republic of Michigan or some other nonsense of this type has absolutely no validity anywhere. You can't be a citizen of something that does not now or ever has existed. This is just another sovereign citizen propaganda set up to get you in trouble with the law by claiming this stuff. During our years through our own progression, both Endall and I had interfaced with the Patriot community for a certain period of time. What Endall noticed most of all about most of these people before he walked away from the whole thing in disgust was that the vast majority of these folks would buy these sovereign citizen packets or Xerox the information and pass it around. This was in the days before the internet. Or they would attend meetings and get themselves all full of righteous indignation over the injustice of it all. What was most evident is the fact that very few of these people ever darkened the door of a law library except the most die-hard leaders of the movement. The vast majority just took these people's word for how all this stuff worked to circumvent traffic tickets and give you an out for not paying your income taxes or whatever. Endall told me he doesn't regret his time interfacing with the Patriot movement, for that is what prompted him into his own study of the law, but that is probably the only positive outcome of his time messing with that, other than being able to speak with experience on these matters. We are not outsiders poking at people who believe in the sovereign citizen movement. We have both been there and done that to a certain degree and have outgrown it. We will be the first to admit that there is a massive global conspiracy taking place, and there is more than enough substantial and verifiable evidence to support this without having to reach into quasi-legal bogus arguments over traffic offenses and being civilly disobedient to the point of belligerence. Think about it. Such activities play right into the hands of those who do have a plan to tear this nation apart, sow dissent, and ultimately take full control. These people are the Marxist Fabians, and there is no shortage of information and verifiable facts available to illustrate exactly how their Marxist globalist subversive agenda works. The early Fabians felt that Russia under communist control was the best form of government ever created. This fact alone should tell you exactly where their New World Order agenda is focused. Subversive Marxist tactics are to sow divisiveness in a culture so much that it eventually implodes on itself. The Black Lives Matter movement is financed by Fabian globalists, as is the feminist agenda. I have little doubt that the so-called patriot movement is just another Fabian propaganda fallacy to turn Americans against their own government in an attempt to create a violent revolution and to sow dissent, divide and rule. The latest protests by the liberal left after Hillary Clinton's election loss are allegedly financed by George Soros, another rich Fabian stooge, working to undermine the U.S. so the Fabians can fold us into their United Nations-controlled New World Order. For all of you ignorant liberals and anonymous followers who jumped on the Occupy Wall Street bandwagon, somehow thinking that Wall Street and the bankers are some kind of conservative adversary, you should all know that the Wall Street and international bankers have been working in collusion with the Fabian Marxists for well over a century. Sidney Webb, one of the founders of the Fabian Society, produced a pamphlet in 1901 called Socialism for Millionaires, designed to attract monopolistic bankers to their Marxist cause. I'm posting the link for this pamphlet, which is available from the London School of Economics website for those who doubt this information. By the way, the London School of Economics, or LSE, was also a direct creation of the Fabian Society, as was Chatham House, the Council on Foreign Relations, and many other offshoots. The financial wing of the global Fabian Marxist agenda is comprised of the richest banking and industrialist families around the world. The Rothschilds, the Rockefellers, the Carnegies, the J.P. Morgan banks, Lord Alfred Milner, and their British counterparts, which comprise the Milner-Fabian conspiracy. So, all of you folks thinking that you are protesting over presumed Wall Street capitalism and monopolism are actually protesting against the very people who underwrite your movements. It's called liberal capitalism and has nothing to do with real capitalism, but everything to do with Fabian Marxist state-controlled monopolies. For those with inquisitive minds and that don't mind reading a book, I'm posting a link in the description section for a PDF download of a book called Fabian Freeway, High Road to Socialism in the USA by Rose Martin, published in 1966. For a more updated version of Martin's work alongside a study of the Fabian historian Carol Quigley, you may be lucky enough to get a copy of The Milner-Fabian Conspiracy by Iwan Radu through the only bookseller we found that had any copies of this book out of the UK. This book was published in 2012 and is already out of print everywhere else we looked. We feel fortunate to have gotten our copies. The link for that particular bookseller is also in the description section below. And ladies and gentlemen, I just finished reading this book. I highly recommend it if you can get your hands on it. It is thorough, detailed, very comprehensive piece of work. The Fabian Marxists know exactly which buttons to push in any given culture through propaganda and the use of agents, provocateurs, to rile up the population in order to fulfill their agenda. They will incite rabid anti-government patriotism just as easily as they will incite racial or sexist tensions. They don't care what brand of propaganda bullshit egos buy in their own sense of persecuted paranoia because they are experts at pushing anyone's buttons. That is until one can see through the psychological manipulation and stop rising to their bait. If the members of the global public want to see this thing turn away from the road to tyranny, we are being forced to march at the tempo of the Fabian drumbeat. You better fucking realize just who the real enemy of humanity is and how they play your egos like a fiddle. We've done over 100 videos showing the Fabian perfidy in both the alleged spiritual arena as well as the political arena, and if people don't wake up to who the real enemy is, with their armies of bureaucratic agencies, their bogus communist-controlled United Nations, their tens of thousands of tax-free foundations and propaganda mills, and their armies of proponents who flood all the media airwaves with propaganda and fear, they will continue to destroy every culture on the planet except the one that most suits their agenda for total global domination. Get over the idea that it's just a global Jewish conspiracy. The Zionist movement was created by the Fabian Marxists and British banking interests. Zionism is nothing but Marxism in disguise and only one wing of the Fabian sphere of influence. We find the same influence through a Marxist pope and Marxist Jesuits preaching liberation theology and revolution from the pulpits around the world. The Fabians and their theosophist allies think they have all the bases covered, and so long as they can manipulate small-minded and paranoid egos through fear and psychological manipulation, they will have the upper hand. What we advise our viewers to do is educate yourselves to these tactics and once and for all stop taking their bait. Grow your consciousness beyond such tireless psychological manipulation and stop being puppets on the Fabian strings. I realize this is a big pill to swallow for some of my viewers, but this pill is no bigger than any other we have provided in these videos. It's time that humanity once and for all grow some genuine common sense and stop falling for pastoralist Fabian herd manipulation bait. The world is imploding in on itself at the hands of the Fabian manipulators and their designs. Europe is being torn apart through forced multiculturalism and controlled destabilization. The enemy has been identified. Stop looking at little pieces of this puzzle, thinking your little pieces gives you all the information to have it all figured out. See the big picture, for until you do, you will only be manipulable puppets on a global Fabian-created stage. One piece of advice we'd like to give those getting involved in the sovereign movement or studying aspects of law is simply to be very careful. As we pointed out in the video Common Sense Revolution Part 2, acting with belligerence towards cops and judges is not going to get you anywhere except, perhaps, a jail sentence and hit with heavy fines. I'm including an article below from the U.S. Attorney's Office from the Central District of California outlining the charges that a California couple now faces for filing false income tax returns, it is claimed. It's claimed that the couple used fictitious financial instruments, and they are also charged with conspiracy to defraud the United States. They both face ridiculous prison sentences, basically life imprisonment. My point with this is to be very careful when you get into this stuff. If you are going to apply some form of administrative procedure, you really need to know what you're doing and what you're getting yourself into. If you are going to file documents in an administrative process with the money powers, you really need to think it through. People are selling this legal information in books and seminars, and people apply it and in many cases get into serious trouble, so be very, very careful. Ladies and gentlemen, once again, thank you for joining me, for taking your time to listen and to consider new ideas. It's greatly appreciated. I extend my gratitude and my deepest thanks to any and to all who take the time to open their minds to search for truth and to push forward in their own conscious advancement and willful evolution. Once again, thank you so much for listening. This is Doug Michael, and until next time, walk in peace.